and then this guy comes and says delete it, and I know I have a California obligation, I delete it, and then the other guy says, wait a minute, you knew that there was litigation coming, there was a newspaper article, or I sent you a demand letter, you know, there's something that
you shouldn't have been deleting that. Welcome back, eDiscovery viewers. Today we're talking about CCPA. CCPA, if you don't know, is California Consumer Privacy Act. And we have Yitzy joining us today. The conversation me and Yitzy had about CCPA is, Yitzy said we should make a video about this. We should let our clients know what it is. Our viewers would be interested. And I said, no, they will not be. That is a totally boring topic. And as an eDiscovery vendor, we completely don't care about CCPA. But after long conversation and me losing my voice, here we are in the studio talking about it. Yitzy, tell us why, as an eDiscovery vendor, we should be concerned or at least interested in some way about CCPA.
So the CCPA can impact eDiscovery from a couple of points. One is not necessarily when it comes to us. If you're working at a company and you have to be able to work with them for to meet their discovery demands, one of the things is you're supposed to have data mapping, so you know where the data is to be able to locate it. And this might actually make it not harder, but actually easier, because you're going to have to keep track of things, because you have to fulfill certain privacy requests, or you might have to disclose it to the client. From an eDiscovery perspective, from us, is what happens if they have information that the client, because of the consumer has the right to deletion. Now there are exceptions, obviously, if there's a legal obligation. If the person says, I want my data deleted, everything, and now they're subject to a litigation.
Before you continue further, the first point I hear is that the clients, the corporations, will have to have their data organized better, which may affect how we collect that data. So usually when we go in and try to grab lots of data from unstructured databases, it's all sort of a mess, and we try to make sense of it. Having this implemented will force our clients have data better organized, which in turn can help us better collect it.
Yes, I think that they'll have to have more structured. In fact, that's one of the things, one of the principles about eDiscovery is you're supposed to have your data structured if you're constantly in litigation. Know what server it is. I mean, if you have it in the cloud and you have servers in Iowa and servers in India, for example, let's say, you want to know where it is because you got to retrieve it, you know, for the litigation. The second point is that if something that's a CCPA that a client says they want to delete, but it's subject to a litigation hold, it seems most likely you'll still have to be able to preserve it and you won't be able to delete it. So,
so litigation hold will
trump this.
Trump this.
I believe one of the exceptions to deleting data is subject to a legal obligation. But I think it'll be more of a case, what happens if somebody says right before litigation is about to take place, and maybe you should have been aware of, you know, there's always this nebulous thing, when does a litigation hold actually take hold? And now they said, I want my data deleted. So go ahead and delete it.
So this is what we talked about, reasonable anticipation of litigation.
Right, that's very nebulous.
So would reasonable anticipation of litigation trump this or not? So if there is a company that expects to be sued, expects to be in a law case, and someone is asking to delete the data, should they delete it?
If they know they reasonably anticipate. What I'm saying is the idea of reasonably anticipate is kind of vague. I may not realize it, and that's where people get into a little bit of trouble. And then this guy comes and says delete it, and I know I have a California obligation, I delete it, and then the other guy says, wait a minute, you knew that there was a litigation coming, there was a newspaper article, or I sent you a demand letter, you know, there's something that
you shouldn't have been deleting that.
Right, but it's not necessarily clear that it was reasonable, because to me, I saw this thing, the letter was sitting on my desk, I don't know, I read it, it didn't seem like we were heading towards litigation because I thought we could resolve it without litigation. So like, where is it, this intersection?
Right, so that's a gray area, and that's actually interesting, where, you know, we kind of assume, the litigation hold will trump it, but reasonable anticipation of litigation may or may not, and there's that gray line.
Right, because what is reasonably anticipating? That's the thing. If it's clear cut that I'm reasonably anticipating, that would be like a litigation hold. I mean, look, there's also no way to know. It is possible that they might not hold a litigation hold is considered a legal obligation under the statute, but no likelihood I would say that. But again, the courts are going to have to hash that out once it gets to court. A lot of this is going to be a lot of privacy litigation too.
Got it. All right, Yitzy, I guess this was an interesting topic to talk about. You were right. Guys, thank you for tuning in. If you have any questions for me or Yitzy, please leave them in the comment section below. And as usual, don't forget to check out eDiscovery on social media networks listed on your screen. And for previous videos, check us out on YouTube. Thanks for watching.